Welcome, everyone. I'm pleased that you're able to join us. Before we get started, there's a couple of housekeeping matters I'd like to go over with you. First of all, questions are welcome. Please use the Q&A feature. Don't use the chat feature. And then we will moderate those questions as time permits and as the topic proceeds along. Also, for those of you that want to get CLE, you have to stay for the whole hour. And I know that several of you in the past have lost the connection and had to sign in again. We understand that, but if you sign in again under a different name, please email me and let me know. Lori, Lori.Nelson, Nelson @law.utah.edu, so I can make sure you get credit for it. We've had a couple of people have had to sign out under their own name and sign in under a new name, and then they won't get credit. So I want to be able to track that accurately and make sure you get the credit. Also, for people outside of Utah, we don't have automatic CLE credit. We're working on that, but you can apply for self-study credit as far as I know. Now, I would like to welcome you to this session. This has been a pretty hot topic in the news about people wearing t-shirts and hats at work and being told they have to take them off, and the brouhaha that is all caused. So I'm really very pleased to welcome Michael Obrien and Elena to present to us about political speech and the workplace and how those two can hopefully coexist somehow. Mike and Elena are both attorneys at Jones Waldo, U-Law alumni, and yay, go us. So welcome, everyone. And now I would like it to turn it over to Mike to begin the presentation and discussion.
Hey, good afternoon, everybody. Elena and I are delighted to be here with you today to talk about what we think is a very interesting issue. Of course, we're employment lawyers, so I don't know if everybody thinks it's as interesting as we do, but we like it. I have to mention, I'm really excited to present with Elena today. As Lori mentioned, she's a fellow U-Law grad like myself. She's also the daughter-in-law of my good friends and also fellow U-Law grads, Rusty and Phyllis Vetter. So I remember studying intently with Rusty during my first year of law school. And it's very gratifying to be able to work with his daughter-in-law and Phyllis's daughter-in-law now. So thank you, Elena, for joining me. We're going to each present different aspects of this and then come together for a bit of a discussion at the end of it. I normally, as a proud U-Law grad, would normally wear red like Lori's doing, but you know, I've got my green on today because it's almost St. Patrick's Day, and I want to make my dear, sweetly departed Irish Catholic mother proud of me, and so I wore green. Speaking of my Irish Catholic mother, she once told me that the best way to get along with people is to never discuss religion or politics with them. So the last year has been interesting because I've been working really hard with a publisher about a book related to religion, to my growing up at the old monastery in Huntsville, Utah. And here we are now talking about politics. So I'm sorry, Mom. Hopefully people won't be too upset that we're talking about the things we talk about. But I think Mom's got a good point, at least on the politics. If this wasn't a problem, if people didn't get upset talking about politics at work, we wouldn't probably be having this discussion about why employers might choose to try to regulate it. So Mom was right. It is an issue. It's something we have to deal with. Employers in particular have to deal with it. And the goal that Elena and I have set for this program is to, within a very short hour, to give you tools and knowledge sufficient to help you deal with it as an employer, or if you're a legal counsel to an employer, to help you counsel them in that process. Elena, would you advance the slides, please, for me? So those are our awesome pictures. You saw those just briefly. That was probably long enough. There they go, back again. You can move ahead. Thanks, Elena. What we want to do today is talk about three things. I'm going to talk about how private employers should consider dealing with political speech as related to work. Elena's going to talk about how public employers should do the same thing. That's an important distinction because there are different laws that apply depending on whether you're a public employer or a private employer. And then we've got a couple of case studies we're going to talk about in the last 20 minutes or so of the presentation together to sort of help you and help us apply a lot of the facts, as we like to do as lawyers, and work our way through a couple of situations where these issues have arisen. Move on, please, Elena. So private employers and political speech, first slide there. Let's move on one slide, please. There's three main areas we have to consider in terms of legal considerations for private employers. And the first one is federal law and constitutional law. Constitutional law comes into this situation often for employers, depending on whether they're public or private. State and local law have a say on the issue. And then, of course, the common law, for those of you who aren't lawyers, and we may have a few on the program, the common law is the law developed by judges as they decide cases that come before them. And there are certain common law claims that apply in this context as well. And I want to talk about each of them and give you a sense of them so that you can understand what legal implications there may be for regulating the speech activities of employees. If you'd move on, please, Elena. So federal constitutional law, what are we talking about? On this issue, people immediately go to the First Amendment, right? The First Amendment protects speech, and we have a right to free speech. And yes, that is true. But the First Amendment does not apply to private employers. It applies to government. So it applies to public employers. And Elena is going to give us more details on that. So I'll just finish this section of the presentation regarding private employers by reminding you that the First Amendment does not apply in the private employment context. But there are other laws that apply. For example, there are the classic anti-discrimination laws, the laws that prohibit discrimination based on race, religion, ethnicity, those types of things. And certainly those can be applied to issues where an employer is attempting to regulate the speech of its employees. And the National Labor Relations Act, the NLRA, applies often in this context as well. When I bring up the application of the NLRA, especially in Utah, a lot of listeners wonder why I'm even bothering to talk about it, because Utah has so few unionized employees. But of course, you'll remember, and if you didn't know, you'll know from now on, that the NLRA also applies to non-union employers in certain contexts. And we're going to talk about that here for a few moments today as well. Next slide, please, Elena. So what do I mean by classic anti-discrimination law? Well, we're talking then about the situation again where someone is making an allegation that there's been discrimination based on protected classes that are established by federal or state or local law. And those are familiar to many people, lawyers and non-lawyers alike: race, national origin, color, etc. You know, and the classic danger zone hypothetical example I could come up with was involving disparate treatment based on race. Is an employer who fires Black or Hispanic employees who advocated BLM, Black Lives Matter themes at work, for example, but not white employees who wear messaging that says an employer should observe something called White History Month. You know, if the distinction is made based upon race, ethnicity, national origin, color, then the discrimination laws could come into play in some sort of a decision to regulate or monitor speech. Utah anti-discrimination law, the state Anti-Discrimination Act, actually, unlike federal law, has a specific provision dealing with expressive activity. And we'll talk about that in just a moment. That provision doesn't exist again in federal law. So a federal law claim here would have to be based on some sort of adverse action hinging on a racial distinction. Next slide, please. The National Labor Relations Act, how might that law apply? Well, Section 7 of the NLRA guarantees employees the right to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. Now, for the longest time, I struggled to understand what concerted activities were. I mean, is that like, you know, going to a Billy Joel concert together or something like that? And the answer is no, it's not that. Concerted activities, though, is like a concert, because a concert involves a number of people coming together to do something together. And that's what a concerted activity as protected by the NLRA is all about. but it has to be for the purpose of either collective bargaining or mutual aid or protection. And that includes employees who are getting together to talk to each other or possibly engage in action together for purposes of improving the terms and conditions of their employment. So imagine a scenario where employees are talking about a minimum wage bill, right? We saw that issue playing out in Congress as President Joe Biden's COVID relief package has been progressing through the two chambers back in Washington. If employees were engaged in a heated discussion about the minimum wage bill, would that be protected by the NLRA? And of course, the answer to that is the answer to every single legal question in the world, which is it depends, right? If the employees are talking about the minimum wage bill or law in the context of their own situation and trying to somehow press the employer to provide a minimum wage that's tied to a living wage statute or something like that, then it's certainly possible that a political discussion at work would connect into mutual aid and protection of employees and involve the terms and conditions of their employment. And therefore, if an employer were to punish employees for talking about political issues like that at work, the NLRA may give them a cause of action. Next slide, please. How might the NLRA not apply? Well, the political activity that's unrelated to employment is not protected under the National Labor Relations Act. So the mere fact that someone is engaging in political activity is not enough. There has to be some sort of a nexus or connection to the employment. We have an interesting example provided by the NLRB, the National Labor Relations Board, which is the entity that enforces the National Labor Relations Act. The NLRB has a general counsel, and he or she is a person who often helps interpret the NLRA by issuing opinions, letters, or various other guidances that employers use to understand the law. And in one letter, the NLRB general counsel was talking about a situation where an employee had been terminated after he testified and advocated for police reforms as a state legislator before a local county governmental council. And the NLRB general counsel concluded that that situation did not implicate the NLRA for a couple of reasons, largely because it was a personal political agenda of the employee. Certainly an issue that should be considered and discussed, and arguably in the interest of the community at large, but not necessarily related to employment. So there was an insufficient nexus to employment for the NLRB to conclude that prohibiting an employer prohibiting or regulating that sort of speech or punishing an employee for engaging in that sort of speech implicated protections under the NLRA. Next slide, please, Elena. State laws. This is where a lot of the action is, frankly, with political speech and employers. And this is something that employers should pay very, very careful attention to. Now, these days, when you are giving advice to an employer about how to deal with employment law issues or giving advice to an employee, you often have to figure out where they live. And the reason for that is because where they live provides them with protection from the state laws that apply to the state where they live. And a number of states have laws outlining the types of prohibitions on political activity that an employer can and cannot impose on the workforce. Connecticut's is very interesting in particular. Connecticut has a law that basically invokes the First Amendment and applies it to private employers as a matter of state law. There's a really good summary of these issues here. And I've given a cite, an article written by someone named Tracy Oakes Obrien. I'm sure subconsciously, at least, I chose that article because of the very excellent last name of Tracy Oakes Obrien. But it's a very good article that summarizes these issues really quite well. And Tracy Oakes Obrien categorizes these state laws into 6 categories. Next slide, please, Elena. The first 3 categories are here. Acts that coerce or influence employees to support or oppose a candidate or an issue by linking employee political activity to workplace consequences. Another category, threats or rules that prevent employees from participating in any political activities. And then a third category, directing political affiliations or discharging employees based on political affiliations. Next slide, please. There also are state laws, again, depending on the state you're in, that regulate whether an employer can discipline or discharge an employee for lawful off-duty political activities, which can include online activity. There are state laws that deal with maintaining records on an employee's off-duty political activity, and sort of tracking what your employees are doing. And then there are laws that focus on discriminating against employees who refuse to participate in employer communications about political matters. So 6 really interesting categories where state laws regulate what an employer can do in turn to regulate the speech of its employees. Next slide, please. What about Utah law? Well, Utah has a couple of provisions that are very relevant to this issue. So Utah Code 20A-3A-502 has provisions that talk about intimidating employees on voting matters. So for example, employers can't place paychecks in envelopes that have political materials in them. I can't pay my employees in an envelope that says, Mike Obrien for ruler of the world, vote now. I can't seek to tie employment or the paycheck to any sort of political interest of me as an employer. Utah has a statute also that requires employee leave time to vote, and that's 20A-3-103. And most interesting of all, next slide, please, Elena. The Utah Anti-Discrimination Act has some provisions that directly impact expressive activity of employees. So this is 34A-5-112. Subsection 1 deals with what an employee can do at work, and it says that an employee should be given some liberty to express religious or moral beliefs at work if it doesn't disrupt the workplace. Subsection 2 goes a little bit further and talks about work or expressive activities away from the office or the workplace. And it says that if an employee engages in lawful expression or expressive activity outside the workplace regarding their political convictions, then an employer shouldn't be able to punish them for that unless the expression or the expressive activity is in direct conflict with the essential business interests of the employer. Now, there haven't been a lot of cases in Utah under this expressive activity provision yet. It's relatively new, but it is there, and it does apply to this topic we're talking about, including within the workplace. If an employee can categorize their political speech as tied to their religious or moral beliefs, then arguably they have some protection in the workplace for that expression as well. Next slide, please, Elena. And then again, the common law, right? There's a common law tort cause of action in Utah that prohibits employment termination for a reason deemed to be in violation of a clear and substantial public policy, right? The public policy tort claim is how we employment lawyers refer to it. In other words, if an employer lets somebody go for a reason that violates substantial interests of public policy, then there's a cause of action to prevent that. And this cause of action has been used to prevent employers from striking back at employees who file workers' comp claims, for example. It hasn't been applied yet to employees who engage in political activity. There have been other cases in other states where that issue was addressed. And so far, the majority rule seems to be that, as a general rule, political activities are not a substantial enough public policy to support this sort of a common law claim. Next slide, please. So that's pretty much a very short 15 to 20 minute rundown about the law on how private employers can deal with the political speech of its employees. Again, there's an important distinction to be made for public employers, and the rules are a little bit different. And Elena's going to talk to us about that. Elena, take it.
Thanks so much, Mike. I hope you will continue to tell me when to advance the slides, even during my part of the presentation.
I will try to anticipate that and do that.
Well, thank you for that introduction and for explaining the realm of private employers so well. As you said, I'm going to go into some public employer information. So that we would start out, this is very basic and probably a review to a lot of people, but start out with defining our terms. So first off, we can ask, what is a public employer? A public employer is an entity or a branch of the federal or state government. It can also be, a government contractor. And it's not just at the federal and state level. There's municipal government entities, there's local government entities, so they count too. And the general guidelines that bind public employers and safeguard employee speech are a little bit different. As Mike reviewed, right, the First Amendment comes into play with public employers in a way that it doesn't necessarily with private employers at all. And so there's going to be a little bit of con law review here. Stick with me. I've never lectured on cases before, but I'm going to try to make it interesting. And there's only one slide of it, so there's at least that. I think we should start at the beginning, though, which is the First Amendment, right? The First Amendment safeguards employee speech when employees work for a public employer. But it's important to note, and you'll remember this from your con law classes or your con law practice area, that even the First Amendment's protections are not unlimited, right? And so even in the First Amendment context, we never really have the right to completely unrestricted, unhampered speech. That is, there are several categories of speech that have been considered by courts to not really be protected by the First Amendment. Those are things like, fighting words, true threats, obscenity, things like that. Generally speaking, speech can only really be regulated as a last resort when the reasons to do so are very, very strong. So public employers have to keep that in mind. And speech, the other thing to keep in mind is that speech has been defined by courts to be much broader than just verbal expression. As Lori said, and as Mike said, things like wearing certain hats or shirts with slogans or logos on them may be considered speech. And then actions such as the famous flag burning case, and even spending money can be considered speech. And so in terms of what kind of speech the First Amendment protects, it's a pretty broad protection, and courts keep that in mind as they apply these protections to public employers. Here we go. Here's our review of some Supreme Court case law. This is by no means exhaustive, but it's going to take us through kind of the heavy hitters. The first place we've got to start with is Pickering. Pickering is a case that's taught in most con law classes, and for good reason. It's really the case that kind of fundamentally establishes how the Supreme Court is going to ask public entities to weigh the rights of their employees when they're trying to determine whether or not to discipline them for their free speech. So Pickering is a case about a teacher who writes a letter to the school board complaining about funding policies and other ways that the school board is run. The teacher sends this letter and is ultimately let go. And the court takes up this very issue and is very clear from the onset, says very specifically, public employees can't be compelled to relinquish their First Amendment rights just because they work for a government actor. And for the most part, your First Amendment rights that you get to enjoy as a citizen to comment on matters of public concern should be safeguarded. But at the same time, the court looks at the interest of the school board and says, yeah, the school board also has an interest in regulating the speech of its employees for its own efficient and safe ability to carry out the public business, right? So there's sort of a balancing that's going to have to go on, as the Pickering court recognizes. And Pickering generally stands for the proposition that public employers must find a balance between the interests of their employees to comment upon matters of public concern and the interest of the state as an employer in kind of promoting the efficiency of the public services that it performs through its employees. The letter at issue in Pickering ultimately didn't interfere with the regular operations of the school. And so the court concluded that the school's administration's interest in kind of limiting that speech was really not significantly greater than the state's interest generally in limiting that type of speech for other members of the public. So in this case, we have this balancing of interests that's set up. And it considers, was the speech in the realm of public concern? Did the speech really impede the operations of the public employer? That's kind of what Pickering sets up. Connick comes next. And in this case, the court more clearly instructs public employers to begin by thinking about whether an employee's expressions that they may otherwise want to discipline them for were made by the speaker as a citizen upon matters of public concern. So that's two parts, right? Both in regards to whether they're speaking as a citizen or as an employee of this public entity, and whether they're speaking about matters of public concern or something that's just a matter of private concern. As the court's decisions have noted over time, there was at one point kind of an unchallenged dogma that when you signed up for public employment, you were signing up for some sort of restriction of your rights. But through Pickering and Connick and these other cases, the Supreme Court kind of pushes back on the idea and says, no, we're still going to have to safeguard the First Amendment, right? And political speech is right at the heart of the First Amendment. It's never been one of those categories of speech that can be sort of unprotected because it incites violence. Although, as we'll see in some of our case studies pretty soon, sometimes it does, and then that becomes kind of a trickier question. But in Connick, basically the court says public employees do not surrender all their First Amendment rights just because they've signed up to be a public employee. And in particular, when the matter that they're addressing is one of public concern, that weighs in the interest of protecting their free speech. So after Pickering and Connick, basically we've got two questions identified for public employers to keep in mind. The first is whether the employee speaks as a citizen on a matter of public concern, right? If the answer is no, the employee has no First Amendment cause of action. And the second question is whether the employer, this is the balancing question, has an adequate justification to treat their employee differently from any other member of the general public when they decide how to discipline or restrict speech. So essentially, even though a government entity has broader discretion, certainly, to restrict speech when it acts as an employer, the restrictions that it imposes must be directed at speech that has some potential to affect that government employer's operations. Garcetti is the next big case in this line. You can see about 30 years have passed before the court gets to Garcetti. And in the interest of time, I won't delve too far into this one. But essentially here, the court kind of highlights how robust the public interest is in informed and vibrant dialogue. So the government doesn't just have an interest here in making sure that employee speech is not getting in the way of the government's functions. The public also has an interest in maintaining really robust dialogue, including maintaining the ability of public employees to voice their opinions on matters of public interest. And so essentially, there's this interest that's capturing this ongoing dialogue between citizens and how important that is. And I think that even as the court is kind of emphasizing that, it also has this very on-the-nose line in this opinion. The court writes, while the First Amendment invests public employees with certain rights, it does not empower them to constitutionalize the employee grievance, which I think is really, really important, right? It's showing that sort of balancing. And in this case, ultimately in Garcetti, the court adds one more kind of question to the Pickering-Connick test. And it says, basically, when a public employee is speaking in their official capacity, instead of in their personal capacity, not as a citizen, but as an official, that particular speech has no First Amendment protections. So those are going to be the three questions that are going to kind of guide our analysis. And then I've put this last case in here because I think it's quite interesting, fairly new. I know it's new because I couldn't find a US Reporter site to it. That's how I know that it's new. So in this case, the petitioner is a police officer whose mom is bedridden at the time of this very closely watched mayoral campaign in his hometown. And his mom says to her son, hey, will you go get me a yard sign for the candidate that I like? And he says, sure, Mom. So he goes to the campaign site and picks up a yard sign and chit-chats with his neighbors and then goes home. Well, other police officers see him doing that and they report him. And the very next day, he's demoted for his overt involvement, is what the police say, for his overt involvement in that campaign. He files suit And he says, whoa, 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 whoa. No. That's not what was going on. I wasn't overtly involved in anything. I was just doing my mom a favor, right? But the court takes this up and basically asks, whose perspective are we going to judge the First Amendment protections on the basis of? Is it going to be from the basis of the employer, or is it going to be from the basis of the employee? If the employee says, I didn't mean to engage in any sort of protected speech, does that mean that this speech is unprotected and that essentially the employer can go ahead and discipline? So the court takes this up and answers that question in the negative. It says, no, the First Amendment was drafted in a way that would prevent the government from restricting speech. And so even when there's a question of fact, even when there's like a mistake, like there was in the underlying facts of this case, where the employer believed that something was political speech when it actually wasn't, if the employer ends up disciplining the employee for that speech, it means that the speech ends up being protected. The First Amendment is triggered, and it can be the sort of thing that would violate the First Amendment. So I thought that was kind of an interesting case. It's a little bit of a niche in the case law, but I can certainly see, and I haven't practiced employment law for nearly as long as Mike has, of course. So this hasn't actually happened to me yet, but I can see a potential case arising where the employee says, hey, listen, you thought I was engaging in political speech, but I actually wasn't. Does that kick the case altogether out of like the First Amendment purview? The Supreme Court says, no, it does not. All right, thank you for sticking with me. Here is the balancing test. Now that I've talked a lot about all of the different factors, here's what public employers have to ask when they decide what sort of discipline is actually allowed by the First Amendment, right? The first question is whether the employee is speaking as a citizen or as a public employee. If they're acting in their official capacity, the First Amendment does not apply to that speech. The second question is the employee speaking on a matter of public concern? If the employee is not, and they're just talking about something private and personal, then that speech is not protected in the same way. Because of course, the First Amendment jurisprudence really values this like civic dialogue that it's trying to protect. And then the third question is a balancing test. All good con law tests end in some sort of balancing, right? And the question is, how are we going to balance the interests of the state, which include that public and civic dialogue? They also include the efficient administration of the state's business. And then the interests of the employee, right? And being able to express whatever they would want to express as a citizen and as a member of the general public. So that is the test that we have to keep in mind going forward. Is that all? Is that all that public employers have to think about? I bet if this was an in-person session, I'd see a lot of heads shaking around the room. Of course it's not, because we have statutes. We have federal statutes and we have state statutes. And as Mike said, they're both, I mean, especially on the state level, they get to pretty granular details in terms of what they allow, not just for private employers, but also for public employers. I've put one, this is by no means an exhaustive review, of course, but one big federal law that sort of addresses this sort of balancing between the federal government's interest in the robust dialogue and also in maintaining efficiency versus the employee's interest is the Hatch Act. And the Hatch Act governs political speech, what's allowed and what's not allowed by employees of the federal government. So this is pretty interesting, I think, and is a good way to illustrate how the legislature, at least, has tried to balance, how Congress has tried to balance these competing factors. So what Congress has done is they've basically delineated two kinds of federal employees: less restricted employees and further restricted employees. I'm not going to read these things off for you. You can read them yourselves, but essentially, less restricted employees can do more political speech in more ways, and further restricted employees have less of the opportunity to do that. And of course, that's kind of tied to their ranking within the system. The more that you are seen as a public figure in your official capacity, and the more that people kind of relate to you as a member of the government, the less likely it is that you're going to be able to participate openly in political campaigns, even in your free time, even when you're off duty. The Hatch Act also has, I think this is pretty interesting, a forward-thinking section that talks about social media and email and political speech that kind of go through those channels, right? The Hatch Act says, well, on-duty social media use for political activities is prohibited, and even the forwarding of political emails while on duty or from a government email address is also prohibited, and that's for both classes of employees. And I think that that's kind of an interesting way to curtail the spread of information that, of course, we get over social media nowadays. And here it is, right? The 21st century just brings a lot of issues. We're going to talk about them, like I said, in our sort of back and forth case studies that are new and that courts are still trying to wrangle with, and legislatures are trying to wrangle with for the first time. So Mike and I, moving on to Utah law, Mike and I put together our slides separately and then came together and compared. And this was the one slide that we had both put in our presentations. And I will tell you, it's because it applies to both kinds of employers, and also because it's quite interesting, it's quite broad, and it's important. Mike is right that not a lot of cases have been brought under this statutory section. But I think as employers structure their policies and try to figure out their best practices, this is certainly something that Utah employers should keep in mind, regardless of whether they are a public or a private employer. There are a couple of more examples I'd like to share with you. The first is this, right? So this is a municipal section of the code that addresses municipal employees. And it says, essentially, it's one of those categories that Mike went over with us, that partisan political activity can't be a basis for denying employment, that it can't be a basis for promotion or disciplinary action, right? And that means, again, it's sort of building in those First Amendment protections into the Utah Code, kind of doubling down on the same protections. However, it's also building in some protections for the government's rights and the government's interests in this. It says, even though you can't be disciplined for that sort of political action, you may not engage in political campaigning during the hours of your employment. That certainly makes sense. You may not use public equipment while engaged in your political activity. I don't really know. I guess that would be like driving around in a truck or something like that that's owned by the state. And I think this is, again, a pretty interesting way for the legislature to address the balancing test. And then finally, I have this slide. This is pretty interesting. The state of Utah has published social media guidelines for its own employees. And I've just pulled 3 sections out, but there are many sections. And I welcome you to go peruse that website, because I think it's really well done. And I think it actually provides some good language, even for private employers to look at as they're putting together their social media policies. But as the state recognizes, right, people know that you work for a public entity sometimes if you do. And so you have to be extra vigilant, extra careful about what it is that you post, especially because it can spread like rapid fire, right? And I like this line in leadership that says, there can be a fine line between healthy debate and incendiary reaction, right? And that's exactly it. That's what employers are trying to sort of toe in terms of figuring out how to make sure that even private employers feel this way, right? This isn't just public employers are bound by the First Amendment, and so they're trying to safeguard employee speech. Everyone wants to make sure that people feel comfortable at work and they feel like they can express themselves within reason. But this line between healthy debate and incendiary reaction is what we're all working towards. So here we go. Mike and I got together at the end of putting together our slides and kind of decided to powwow on what we could possibly say is like the one takeaway slide here. After the one with just our names and faces, because that one is great, I would say this is the takeaway slide, right? These are the 3 things that you should be asking as an employer, regardless of whether you're a public or a private employer, is you're trying to think through what sort of policy you can put together for disciplining on the basis of political speech. The first question you want to ask is whether there's a federal or state or local law that is directly on point. If there is, you got to follow it. You got to learn it. You've got to follow it. And of course, if you have any questions about it, we are happy to talk to you at any point. The second is there an indirect addressing of these issues? The NLRA applies to public employers too, not just to private employers. And so that's something to keep in mind. And you want to think about anti-discrimination laws, especially in the context of how you're actually applying your policies. And finally, you want to think about whether there's really a nexus between the political speech that you're trying to curtail or discipline or control or regulate, and the employer interest that you actually legitimately have, right? And so what's the likelihood that you can really show a direct link between the speech and the operation of your business? So you've got to keep all those things in mind. And with that, I'm going to turn it over to Mike to introduce some of our case studies.
Thanks, Elena. Nicely done. That good ULaw education is showing in your knowledge and your effective presentation skills. So nicely done. We wanted to sort of spend the last part of the program talking about a couple of cases and sort of analyzing everything we just told you in the context of a specific hypothetical. So let's go ahead and jump in and do that. Would you hit the next slide, please? We have two. These are completely made up, right? These are not stripped from the headlines. I did not plagiarize news articles or any cases to come up with these facts. They're from the fertile recesses of my ULaw mind. But we have one called the mask case, and we have one called the lanyard case. So let's dive in. So the first one, the mask case, right? What's that all about? Well, here's the basic facts, right? Employees, like all of us over the last year, are required to wear masks at work. Several employees of various races start wearing masks at work with BLM, Black Lives Matter, messaging. The involved employer supports the BLM movement, but has a dress code that prohibits any messaging except its name or its brand. Now, like a lot of policies, it's been selectively enforced in the past. So in the past, employees have been allowed to wear LGBTQ plus clothing or hats or shirts, and NRA messaging has been allowed as well, just as a couple of examples. However, when these employees start wearing BLM masks at work, they start to encounter various adverse responses from the employer. So some of the employees who are wearing BLM masks are sent home. They're told go home and change or go home and come back the next day. Some of them are actually fired. And of course, in the great American tradition, a lawsuit follows after these particular adverse actions occur. So we want to take some time to talk about this from the private employer perspective, and assuming this is a private employer involved, or from the public employer. So I'm going to jump in and think about some of the, do some issue spotting, right, on some of the issues that we focus on for a private employer. So we first think about the First Amendment, right? The First Amendment is not going to apply to a private employer in this context. In all likelihood. And so that doesn't give the employees any protection and it doesn't create any restrictions for the employer in terms of regulating the masks that have BLM messaging on them. What about the National Labor Relations Act? Well, for a private employer, the law will apply, but again, this doesn't seem to be necessarily involving terms or conditions of employment. It's a general, it's a passion on the part of the employees on an important issue that affects the public in a very general way, but doesn't seem to be the sort of issue that focuses on terms or conditions of employment. What about the race discrimination laws? Well, we would wonder, is there selective enforcement based on race or ethnicity or any of those sort of categories? Certainly, if there was, there may be a cause of action under the traditional discrimination laws. Of course, obligation of the employees would be to prove that race is the motivating or a motivating factor in the employer's decision as to how it's enforcing its dress code that involves masks and messaging beyond the brands of the employer itself. So certainly, those are the federal laws and a brief assessment as to how they might apply. What about state law? Well, assuming that this employer is in Utah, for the sake of discussion, we have that law that Elena and I have just talked about, really, which is somewhat unique for discrimination laws in that it directly addresses expressive activity. And it says if expressive activity is going on in the workplace based on religious or moral convictions, then the employer can't regulate it or punish the employee unless the employer can show a negative impact from the expression on the job. And this looks like it's occurring at the work site. Remember, political speech off the work site, if lawfully engaged in, is protected for employees. Again, unless there's a clear impact on the employer's legitimate rights. So here, the employees would have to articulate that their BLM messaging stems from a deep moral or religious code. And that's possible, right? That's a possible argument here that an employee could make, which would then allow them to argue they have some level of protection under the Utah Anti-Discrimination Act regarding the messaging at issue here. And the employer would then have to show, in order to regulate the speech, that the BLM messaging is having a negative impact on its essential or legal interests. And if the employer can make that showing, I think the employer has some ability to regulate the speech. If not, then by regulating the speech, the employer may well give a cause of action to the employees under Utah law. So that's a pretty rough and quick and cheap and dirty assessment under the private employer laws. Elena, what about public employers? How would they confront this issue?
Well, public employers will have to start with the First Amendment, right? The First Amendment analysis. So first, we're going to have to ask whether these employees wearing these masks were engaging in this speech in their official capacity. You've already got kind of a thorny question there. Are you engaging in the speech in an official capacity because you went to work? Does just going to work constitute an official capacity? If it does, then that's the end of your First Amendment analysis, because if you're acting in an official capacity, the First Amendment doesn't apply, and you're kicking it back to these other laws that Mike already talked through. But let's say that they're going to work and they're wearing the masks, and it's not an action in their official capacity, it's an action in their personal capacity, right? In that case, of course, we have to ask whether they're speaking on a matter of public or private concern. I think the BLM movement is certainly a matter of public concern. And so in that case, you move on to the balancing. You move on to the test that asks, how are we going to balance the employer's interests with the employee's interest? The employee has an interest in speaking up and exercising her First Amendment rights. The employer has an interest in the efficient, doing of the government's business. And so I think public employers who are on the CLE with us will agree that there are certainly specific parts of the government and the government's business that may be more affected by messaging like this than others. And so, as you said, it might depend, and it might depend on what sort of public employer we're talking about in terms of how a court would weigh the interests and how big of an effect mask messaging might actually play in terms of the government's efficient conduction of its own business, right? So that's what I would say. A big, it depends.
Elena, you heard me earlier in the program mention my sweet, dearly departed Irish Catholic mother, right?
Yes.
Well, I have to confess, she'd be a little disappointed in me right now because I told a little white lie. This isn't a pure hypothetical from the news headlines. Would you hit the next slide, please?
Yeah.
So here's the rest of the story for the mask case. In fact, this was a case involving Whole Foods and Amazon, and it came to light in 2020. And the facts are as I presented them to you. And the employees, in response to being fired or having other adverse action taken against them, they filed discrimination and retaliation claims in a Massachusetts federal court. And they lost. The summary judgment was granted for the employers, and the case is now on appeal. In a nutshell, the judge involved said the employees did not assert adverse actions that were due to race. So in other words, there were individuals of various races who were all punished, subject to corrective action, faced adverse action because of they were wearing these messaged masks. And so the employees weren't able to show or even allege that the adverse actions focused on race. And the judge involved said the inconsistent enforcement of the policy is not necessarily a race bias issue, unless they can show, again, that certain people who wear certain messages of a certain race are fired, whereas others who do the same thing are not. The judge also noted that the BLM messaging was in support of a general social issue as opposed to specifically related to the employment, and thus wasn't protected action. Now, the language from the judge's opinion is really interesting. I'm going to take a minute just to read a bit of it, because the judge, after throwing out the case in closing, said this, and I'm quoting, "It would, of course, be more honorable for defendants to enforce their policies consistently and without regard for the messaging, particularly where the messaging selected for discipline conveys a basic truth. Nevertheless, not all conduct that touches on race is actionable under Title VII. Here, even assuming the truth of the allegations in the complaint, defendants did not discriminate on the basis of race. However, rather at worst, they were selectively enforcing a dress code to suppress certain speech in the workplace. However appealing that might be, it is not conduct made unlawful by Title VII." So maybe it's a case of the employees choosing the wrong cause of action, or maybe they just should have chosen to live in Utah instead of Massachusetts, because maybe they would have had an expressive activity cause of action. So, you choose the wrong cause of action, you often lose in court. What about the lanyard case, Elena? Why don't you tell us about that one?
Well, the lanyard case, as you might all guess from this image that we've got on the slide, is one that we couldn't credibly say that we had made up ourselves, unlike the mask case. So I'm glad the mask one came first with your little white lie, Mike. The insurrection at the Capitol, right? That's kind of what we're looking at here. Say that an employer learns from media coverage or other videos or photos that one of their employees was involved in the rioting at the Capitol and in the insurrection. Not only that, but the employee was also wearing Trump and MAGA messaging. So the way that the employer identifies this employee in our hypothetical based on a real case is a lanyard. And that lanyard is issued by the employer. It has the employer's name on it. So not only can the employer identify who this individual works for, everybody who sees this picture can identify who this individual works for. What can the employer do? What can the employer do in that instance? I'll go first. I can talk about public employers. Again, you have to run it through the same First Amendment analysis, right? So here, especially if they're a federal employee, but also I would say if they're a state or municipal or local government employee, most likely a court would find that this individual is not acting in their official capacity in rioting at the Capitol, right? So that's the preliminary question. We can get that out of the way. Next, the question is, was the employee speaking on a matter of public or private concern? Now, you can imagine, because you all know how con law works, there are a lot of different ways to determine what's public concern and what's private concern. But for the interest of our analysis, let's say that this is also a matter of public concern, right? Political speech. we get to the balancing test. We have to balance the employee's interests against the employer's interests here. We can also think about, of course, statutory language. If the Hatch Act applies, depending on whether you are a less restricted or more restricted employee, or I would say, regardless of which of those you are, actions like this are most likely prohibited by the Hatch Act. There's also, of course, as Mike said, state law that's going to be in play. And so once again, it depends. But you can see how as an employer, especially a public employer, you can probably make a stronger case here that acts like this actually impede the ability for your public entity to do its job, more so than wearing a mask to work. That's what I would say. What do you think, Mike? What about private employers?
Well, Elena, I have to tell you, the main thing I learned from this case is not to wear my Jones Waldo sweatshirt next time I go rioting at the Capitol. So, I think that's a valuable lesson right there. The issues are basically the same, right? This is expressive activity. It's away from the workplace. So a private employer is going to be focusing on, that Utah statute that protects private activity or expressive activity away from the workplace, as long as it's lawful. So, if the lanyard guy is rioting and breaking the law, he's not going to have a cause of action under Utah law. And if the expressive activity disrupts the employer's legitimate interests, which it may well do here, given the widespread publicity that this employer got from having one of its employees wear his lanyard into the Capitol, then the employer has a lot of leeway to deal with it. So what's the rest of the story here?
Well, here's what happened. The employee was let go, right? This is an employee of a national marketing company, a marketing company.
Well, this is a form of marketing.
Well, this is a form of marketing, I suppose. Apparently not the kind that they would have liked, right? So, and this isn't the only time that this happened. There are other examples in the news of similar suits, similar decisions by employers, I should say, to let employees go who were seen at this riot, right? The CEO from another company was fired, and he said after the fact that being there was the single worst personal decision of his life. Of course, he also got fired, so maybe it would have helped for him to say that before that employment action took place, but maybe not. A Texas insurance company lawyer, same situation, who was seen, and this was so publicized that it's hard for an employer not to really be faced with the decision of what to do about it, and to have to make sort of a decision maybe on the fly if there aren't employment policies in place, or maybe within the context of employment policies that already exist. And then another protester lost their job as an adjunct lecturer. So certainly lanyard guy was not the only one to face an adverse employment action from something like this, but this is really extreme political speech. And so I think we shouldn't be surprised that the news coverage backs up that employers are deciding to do something about it.
Well, okay. Well, why don't you wrap this up for us, Elena?
Here we go. It's another slide with us on it. Thank you so much for letting us present today. This has been really great. Hopefully the next time we get to do this, we will all be in person. And, Mike and I are happy to answer any questions that you may have now. Lori, if you have any questions for us, we're happy to do so. And if not, then please feel free to reach out to us with questions or feedback at your convenience. We're really glad to get to do this. So thank you all.
Well, our thanks to you. This was amazing. It was full of really high-level information as well as practical information. So I'm very grateful to the two of you for putting in the time and effort to put this together. And I'm grateful to all of you who are able to participate and listen. And I look forward to having you at one in the future. Thanks so much.